thank you for visiting Graphene Business Law. If you're visiting this video on YouTube, go ahead and click on the red subscribe button down below. Here at Graphene, we regularly post content that is most helpful to small business owners and entrepreneurs in Toronto and throughout Ontario. My name is Pamela Matani, and I'm the principal lawyer and founder here at Graphene Business Law. Today's topic is one that has lingered around for years, the same amount of years. Well, it's gone on for far longer, but it has been hottest for the same amount of years that COVID-19 has been around, and that is the doctrine of frustration. This doctrine has been one of the most quoted doctrines during COVID times because it's basically that concept when you as a small business owner are wondering, I can't fulfill this contract. It's not because of my fault. Something has happened. COVID has made fulfilling this contract impossible. And the question you may have asked is, how do I get out of it? How do I make the damage of fulfilling this contract in times where I can't less bad for myself and my business? How can I help my business? I'm looking at this really hard to fulfill contract as a result of the pandemic. It wouldn't have been something that was out of the ordinary before, but COVID-19 has made a lot of business concepts harder to fulfill, and that of course includes the everyday realities for small business owners and operators and entrepreneurs. So I have a few comments here just as a high-level overview. Maybe your business is going through a rough time, maybe you depend, maybe you're on the other side, maybe you're not the party that's looking or that is no longer able to fulfill the contract. Maybe you're the party that's depending on another business person to fulfill their end of the deal, and you're wondering, well, how can they get out of this? So this video, I want to briefly touch on a few keynotes of what the doctrine of frustration is. I know that for a lot of us, there might be the inclination to turn to the internet and try to uncover things on our own, but it really is a complicated concept for the everyday small business owner. It comes with its own legal tests. It comes with its own scenarios where it just simply can't apply, although to the naked eye, it might seem that this would be a good doctrine for what you're going through. It's a complicated concept in terms of what the conversation ends up looking like, whether in front of the court or in settlement with another party, or anytime you're going to start and take action and take legal action toward that other party. Again, whether you're the party that can no longer fulfill a contract and somebody's coming after you, or whether you're the party that's waiting for the other guy to fulfill his end of the deal because you may have fulfilled yours prior to COVID-19. And not even COVID-19 starting for the first time, but we've had so many rounds in Ontario of COVID-19 impacting our business. 3 years into COVID, or 2.5 years, depending on how you look at it, Ontario small businesses continue to deal with uncertainties in the face of COVID. There's measures and restrictions in place still today, and still not lifted. We are not close to having measures fully lifted. So to recap, this video will provide more of a neutral overview, so it's helpful for both the party going after someone and for the party that's confused about why someone is going after them, despite, it's seemingly now impossible for you to fulfill this contract. First of all, 2 things I want to say right off the bat, because I know how important they are to practical business owners and operators. I myself am a small business owner, and I understand on the other side of the screen, if you're in the position of a small business owner and you're struggling to keep this business alive, I completely empathize with you. But let me say 2 things that are legally important right off the bat with the doctrine of frustration. One is that this is a doctrine that applies when there is no fault of either party at play, okay? And that's a really practical piece of information for you to have. This is not the doctrine that you pull out, or I'll say certainly it wouldn't be the doctrine you could pull out first if somebody has actively stolen from you, if there's fraud, if there's deceit, if there's theft, if there's breach of contract, if there's active wrongdoings. And I understand that maybe you don't know what all of these terms mean. That's not your job. That's my job as a lawyer to know. And that's why here at Graphene, we're here to help working through those concepts. But big picture, I want to say in simple language that this is not a contract where you are smelling the other party has intentionally done something wrong to you or is at fault of something. That's not what the doctrine of frustration is all about. The other second practical bit of information I want to get out the door as a small business owner, your bottom line, although it has the word bottom in it, is probably your first priority or one of your first, okay? And the doctrine of frustration is, the courts have not found it to apply simply because fulfilling your contractual obligations has become more expensive during COVID or even prior to COVID times. Your job becoming more expensive, whether you're a vendor, whatever setup you're in that small business market, your job becoming more expensive is not the reason we go to doctrine of frustration first. And same goes for your job becoming a little bit more difficult. Okay, so that second piece of practical information is that the doctrine cannot simply be applied when in the courts, the language they use is when performing your end of the deal has become more onerous or more expensive. Okay, so when can we use this doctrine? Well, in the event that your contract doesn't have a force majeure clause, you may be able to rely on the doctrine of frustration. This is a common law doctrine, okay? And force majeure is language that we see in contracts, specifically pointing out, acts of God or natural disasters or certain unforeseen consequences, but there's language in the contract already dealing with these question mark scenarios, okay? And the courts have held that the determination of whether the doctrine of frustration is available will, in most cases, be determined by 2 or 3 main factors, including that there is no force majeure clause already in the contract. Because if that language is in there, that's what we're going to look at. And if you think about it, the courts aren't there to babysit business persons. It is not their job to look at a poorly written contract and wave a wand as if it had been a well-written contract. Again, that's part of my job as your business lawyer, to help you out in putting proper language in your contract and language that can offer you the most protection. But where there is force majeure language already in a contract, that's not usually where we see the doctrine of frustration prevailing, because we have to look at what's before us, and somebody has put this language in there, whether it's helpful to you or not, okay? Now, another element looked at is the event itself. As I mentioned at the beginning, the doctrine of frustration will best apply where there has been an event that occurs at no fault of either party. And this event was not one that could be reasonably foreseen or was one that was thought about by the parties. And the event itself is to have a direct connection to the fact that you can no longer fulfill your side of the contract, okay? So the event in question is not some random event that you're trying to link into somehow making your life more difficult. Not that making your job more difficult would be a slam dunk for this doctrine anyways, as I mentioned at the beginning, it wouldn't. But the event must really be, specifically the courts have said, directly related to what is making your contract, your end of the deal, so hard to fulfill now. What is that frustrating factor between you fulfilling what you said you would and where you are now, okay? And again, it must not be something that you could have thought of or that the parties would have been able to reasonably foresee. COVID-19 is, we did see, we have seen in courts that it can have qualified as something that both parties might not have reasonably foreseen. This is not the legal advice bit of the video. There is no legal advice in this video. That's not what these videos are for. However, just reporting on cases, that are already out there, there is case law in place, again, 2-3 years into COVID, to indicate that depending on the facts at hand, it doesn't apply to everybody. This is not a blanket statement, but depending on the specific circumstances before you, it could be that the impacts of COVID-19 on your business can be said to not have been reasonably foreseeable. Okay. The third element is the purpose of the contract. The frustrating event must render performance of the contract impossible, okay, or make the contract one that now looks to be geared towards something totally different than what was originally intended. So to recap this one a little bit, it can't, I shouldn't use can't, but it's not the case that this doctrine will best apply if out of 10 clauses in your contract, the 3 most important can still be met fully, the 3 medium ones can still be met, and the 3 really light criteria may or may not be able to be met. The doctrine of frustration, big picture, is for that very item in your contract that the contract depends on. It is the purpose. Why did you and this other party or these other parties come together and contract? Why? It has to go to that same answer. Whatever you answer the why with, it's got to be that same big picture reason as to fulfilling this contract that has now become impossible as a result of some external factor. So, to recap all of that, the doctrine of frustration can be a very helpful common law doctrine. It's not one we'll typically turn to when there is already language in your contract speaking to a question mark scenario or a mystery, somewhat foreseeable scenario. Natural disasters can be foreseen, certainly to the extent that we write about them. So can, acts of God and everything else we're putting in the force majeure clause. The doctrine of frustration is for things you just could not have guessed, could not have imagined would happen. They've happened, and they now affect the very crux on, which your contract hinges on. If you're a party to an agreement for which the COVID-19 pandemic has rendered the performance of a contract impossible or completely different than had originally been imagined or bargained for, you should contact a lawyer to seek help and to walk you through those next steps and to represent you in what those next steps are. With COVID-19, business owners, particularly small business owners, are being impacted every day. There's money being left on the table every day from unfulfilled contracts, from lawsuits not pursued, from really not knowing, what options you have before you. Even in these difficult times, you still have options, okay? At Graphene Business Law, we are here to serve business persons and business persons only. We're happy to help with matters including doctrine of frustration. It's a matter we are very knowledgeable on, and you can certainly reach out to us anytime at graphenebusinesslaw.ca, info@graphenebusinesslaw.ca if you'd like to email, and you can go ahead and book anytime on our website as well. Thank you for watching this video. I hope it's been helpful. The doctrine of frustration, as the name indicates, the word frustration is in there. It's for parties going through difficult times, and during COVID, those difficult times can be further exacerbated. But you still have options. You can still seek the help you need and deserve. Thanks again for watching.